So, as I said, the common law derivative action is not practical, right? And the last common law derivative action we had was the case of Waddington, which made it all the way to the Court of Final Appeals. The issue in Waddington was whether it's possible for a member of a parent company to sue to protect director damaging a subsidiary. And this was litigated at great length at 3 different levels, but that has been corrected by a stroke of the pen with the new companies ordinance, which includes the member of an associated company, which will be a holding company, right? So now that is expressly included within the derivative action. So we don't really have to worry about Waddington A, because you should not expect any common law derivative action to be filed in Hong Kong, and B, the one problem that we did have in Waddington, which was a member of one company in a corporate group suing to protect the company against damage being made to another company in a corporate group, is something which is expressly allowed today by the company's ordinance. If you're curious about the development of the derivative action or the unfair prejudice action in Hong Kong, you can follow this link, which presents a paper that looks at 20 years of data, basically every action that has ever been filed in Hong Kong, and you can see how they line up. It also gives you a sort of a textbook summary of how the action works. In that paper, what you see is this data. So what we have under the common law was a derivative action that was not terribly popular, and we had a relatively smaller number. And then when we bring in the new ordinance, the statutory derivative action 2005, you see we have a 6-fold increase in the number of actions filed. So that's a significant increase, a 6-fold increase. And so moving from the common law to the statutory derivative action, it becomes substantially more successful to file and win a derivative action. And when we talk about winning a derivative action, what we're talking about here is granting leave. The court will decide to grant leave to the plaintiff in order to allow the case to be heard on the merits. So the elements of the statutory derivative action are pretty simple. And in this lecture, when we look at our application of law problem, we'll once again be looking at duty of care and fiduciary duty in the framework of the statutory derivative action. But I don't expect anyone in the application of law problem or in the final exam, should this topic be covered in the final exam, to make a mistake on the elements of the statutory derivative action, which are extremely simple and are found primarily in 2 sections of the company's ordinance. So first of all, we have section 722, which defines the company we're talking about. And section 722 is not on the derivative action specifically, but it is on part 14 specifically. Part 14 includes basically remedies and tools for members against abuse being done to the company or by the company to that member. So both derivative actions and unfair prejudice actions. For Part 14, foreign companies, which have a place of business in Hong Kong or are registered as non-Hong Kong companies, count as companies. So therefore, Part 14 applies to foreign companies as well. It also applies to associated company, right? So an associated company would be this relationship of companies that have a joint holding company or holding company and subsidiary. The cause of action is in section 732, and it is misconduct. Misconduct is essentially breach of duty for our purposes. It can include fraud, but we will not go into the great details of fraud, right? So fraud, negligence, breach of duty, and that's what we'll be focusing on in order to practice and hone our understanding of the duty of care and the fiduciary duty, but also simply not obeying the law. And what law would we be talking about primarily? Well, the company's ordinance. So if a director fails to comply with the company's ordinance, then that is misconduct and they are subject to a possible derivative action against them. It could also mean any other law, say the prevention of bribery ordinance or any other ordinance that should be complied with by the directors. Right? And so then what they're looking for in a derivative action is statutory leave. They are requesting the court to allow the action to go forward. And this is where the filter comes in. As I said, what we're concerned about is protecting the minority, but what we're also concerned about is that the minority will dominate the majority. And so as always, and I mean really always in company law, when the mechanisms break down and we cannot achieve that fine balance to allow the members inside the company to interact, what we do is we bring in the human being and of the judge. And the judge then will look at a couple of criteria and decide whether this action can go forward or whether the action should stop right here and the minority should stop harassing the majority. So then the criteria are found in section 733. And here they are. The court will look to see whether the action is in the company's interest and also whether there is a serious question to be tried. Actually, what the court does in Hong Kong, as you'll see in the cases, they reverse this because first of all, the court will look to see whether there's a serious question, and that will be the analysis of whether there is a breach of fiduciary duty or duty of care. And then if there is a serious question, there will be a presumption, more or less, that trying this will be in the interest of the company. You might ask, well, why? How could the action never be in the interest of the company? How could it not be in the interest of the company to take care of this? And we'll see that in a second when we go to the Lee case. Right? Less relevant and relatively easy to take care of. The company has not diligently continued an action. Let's say they file an action against one of their directors, and then they sit on it because they just want to wait and let it go away. They do not want to punish the director. There's also a black letter rule that the notice should be served on the company 14 days before the action, and then the court may also refuse if there's simultaneously a common law action going on. There have been no common law actions, but you can see how the court would not want to hear the common law and the statutory derivative action in parallel on the same set of facts. If they came out with contradictory results, it would be not good for the state of rule of law in Hong Kong. So one of the actions will be taken out in order to allow the other action to go forward. Ratification of contact, as I said, is something that we see in the Foss rule, the majority rule, but that has been watered down in the ordinance. So under section 473, we do have the possibility of ratification, and we do have the possibility of most kinds of actions being stopped by member ratification. There is some dispute with misappropriation, which borders on the criminal, and I give you the cases where that's discussed. And then also, if there is a ratification, there must be full and complete disclosure. So the SFC brought forward the complaint in the Styland decision in 2012. And in Styland, there was a ratification, but when the members were asked to ratify, they were not given the complete picture. And so therefore the ratification was invalid because the members did not really understand what they were ratifying. And so that's a fairly good rule to remember, that the ratification can always be challenged if the disclosure on which the ratification is made is insufficient. So what we have in Section 734 is essentially that the court remains in free discretion to decide whether the derivative action should go forward or not, despite the ratification, right? So the member's approval or ratification will not prevent a member from bringing an action, will not require a court to refuse the action, and will not require the court to hold for the defendant. Right? So the court is not bound by the ratification. And then generally what we have as a rule, if you have a well-informed, unbiased members ratifying for a proper purpose in the interest of the company, the court will take this into consideration, and you can probably bet that the court will allow the ratification to go forward if we do have a well-informed, unbiased vote for a proper purpose in the interest of the company. Because as you see, the derivative action ground for leave will be that the action is in the interest of the company. And if the ratification is found to be in the interest of the company, then the action, the derivative action, cannot be in the interest of the company. One of them only may be in the company's interests. And so if the ratification is found to be in that category, the derivative action probably will not be.